Hey everybody, thanks for joining the webinar. We're going to give Zoom a minute or two to let everybody in here. And as people are joining, I'd love to see where people are joining from. Feel free to drop in the city, state, country that you're dialing in from. It's always interesting to see locations and also familiar faces from past webinars that we've done. Milwaukee, San Diego. Hey, Patricia. Hey, Lauren. Awesome. Hillary, Carla. Amazing. Bozeman. Naomi, I think you've joined before. It always reminds me of skiing up there. Las Vegas, Germantown, Maryland. Amazing. Well, thanks everybody for joining the conversation today, which I think is a really important one. And today we're specifically going to talk about the directives issued by the Trump administration that have changed the legal landscape regarding DEI initiatives. We're going to have two top legal minds talking about the implications of these directives for government contractors, federal award recipients, and other public and private companies. My name is Phil Strazula. I'm the founder of SSR. If we haven't met previously, our business North Star is to help companies find and buy the right HR software. And we've been doing these webinars for a long time now. We do a couple a month. They're always a lot of fun. I know we've got a lot of familiar faces on here, and I'm always interested to learn about new topics. And today it's a topic that is on everybody's mind. A couple of housekeeping items here before I introduce our panelists. One, we're going to record this session. Two, it is eligible for HRCI and SHRM credit. We'll send you that information afterwards. Three, we're going to have a dedicated networking session in about 40 minutes where you can share your LinkedIn URL, connect with other people. It's an amazing opportunity to network with other folks who are interested in today's topic. We've had people find jobs, consulting gigs, make hires out of this sort of networking. So it's always an awesome part of it. We're also going to have a $50 gift card giveaway for anybody in the market for HR software, kind of a special offer that we'll talk about in 15 or so minutes. And without further delay, I wanted to introduce our two panelists today. So Ted is a partner of the White Collar Defense and Investigations Group at K&L Gates, a globally integrated firm operating out of 45 offices across 5 continents. His practice focuses on helping clients navigate government investigations and enforcement actions, conducting internal investigations, defending complex litigation, and compliance counseling. Haley is also a partner at K&L Gates. She's also a good friend of mine in the investigations enforcement and white collar practice group. She advises national and global clients on government investigations, regulatory enforcement actions, internal investigations, white collar defense, and complex civil litigation matters. The bottom line is that we've got two amazing people to talk about this. They're kind of up to date on everything going on related to DEI enforcement, rules and regulations, tips and tricks for people who are trying to circumvent potential enforcement. And I'm excited to learn from them today. We're going to launch a quick poll to gauge where people are at in this process and try to tailor some of the content to today. So please take a second to answer this poll. Gives us a little bit of better understanding of the audience. And what I'd also encourage folks to do, if you've been on our webinars in the past, please feel free to use the chat to ask questions, share your insights, share your stories. We'll try to answer some of those questions in real time, and some we'll save for the Q&A section. And again, please save the LinkedIn URLs till our dedicated networking session that's going to happen in about 35 minutes. With that, Ted, I'll pass it over to you if you want to share this presentation that you and Haley have put together, which we're really privileged to take a look at because my understanding is this is mostly for your clientele, which are mostly, these global organizations that pay you guys a decent amount of money to keep them informed of what's going on. And we gotta kind of get a sneak peek into all the tips and tricks that you're sharing with your clientele.
Yeah, thanks, Phil. Thanks so much for having us. Haley and I are really excited to be spending some time with everybody today. And thank you all for filling out the poll. It's helpful to just get a sense of who we're talking to so we could target this really for maximum use by you all. I am going to profess I'm not a tech whiz, but I think I'll be able to share my slides. So hold on one second while I try to do that. And um, all right, I'll ask Phil to just give a thumbs up if he can see what if
We
he can
gotcha.
see. All right. Yeah, thanks everybody for joining. Haley and I are excited to be here today. Here's a little bit of, we will put our contact information at the end to the extent we can't get to everybody's questions during the presentation today, but we're going to try to cover as much as we can. As Phil mentioned, I'm Ted. I'm a partner at K&L Gates. Haley and I work together on government enforcement matters. Other members of our firm handle things like labor and employment law, workplace safety, regulatory compliance, kind of runs the gamut. And I'm based in DC. Haley's in Boston, though we have offices around the globe. Start out, we'll give a little brief overview of what we plan to cover here today. So we're going to start out with just a walkthrough of some of the new developments and the directives that have been issued by the Trump administration regarding DEI. There are several. We'll cover some of the highlights. Next, we're going to give an overview of the False Claims Act. Some of you may be familiar with this, but we suspect many of you have not encountered the statute before. It's a highlight of today's program, though, because it's a tool that the Trump administration has explicitly invoked to address its DEI agenda. So we'll cover some of the highlights there. Next, probably after the networking break, we'll connect the two concepts and address how the administration and private parties might enforce some of the new DEI-related directives through the False Claims Act, through the EEOC, and other avenues to address its DEI agenda. And finally, we'll end with some practice tips as well as questions that we might not be able to address along the way, though we'll try to weave them in. And then, as Phil mentioned, we'll have a networking break in the middle. So without further ado, we'll get into some of the substance. So the Trump administration, as many of you know, has come out with a number of DEI-related directives and policy proposals. The three main ones that we're going to talk about today, and we'll talk about some others as well along the way, starts out the day after Inauguration Day. There was an executive order titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This one mostly applies to either government contractors or federal fund recipients, which based on the poll, I understand, does cover a good amount of folks joining the call today, though not everybody, and that's where the other two will come into play. But this executive order also just discourages DEI in the broader private sector. And we'll talk about some of the ways it does that, and directs that DOJ and other federal agencies identify targets for potential investigation. Next, very shortly after she was sworn in, Attorney General Pamela Bondi issued a memorandum similarly titled Ending Illegal DEI and DEIA Discrimination and Preferences. That memorandum, relatively short, again, we'll get into it, applies to all private sector companies, not just government contractors. And then finally, very recently, just a couple weeks ago, the Deputy Attorney General issued a memorandum that sets out a new civil rights fraud initiative that also applies to all private sector companies. And we'll talk about some of the implications of that in just a couple minutes. So first, the executive order has four main elements. So the first is it revokes an earlier executive order from the Johnson era that had imposed affirmative action obligations on government contractors. Anybody joining the call today that is a government contractor is probably familiar with these requirements that were set out. It's, among other things, required certain statements to be made protecting or identifying that the contractor protects certain protected classes and characteristics. So that
Yeah,
executive.
do you mind
Please.
if I interrupt you for 1 second? Because I'm curious to get your thoughts on, is there sort of an overarching philosophy that ties those three elements together? My understanding from an outsider's perspective is more likely than not, the Trump administration thinks that the pendulum swung too far in favor of DEI initiatives, which they view as discriminatory against typically non-underrepresented folks in the workforce. Is that accurate? Is there something else here that maybe people can think of as sort of a broader framework across these legal elements?
Yeah, I think Phil, you hit the nail on the head there. A lot of this is kind of trying to swing the pendulum back from where they've seen things go over the last several years. The, I mentioned executive order, a couple memoranda that have come out. None of those are laws. Nothing has changed in terms of what's the federal civil rights laws. But things are changing in terms of where the administration is focused, what it thinks companies should be doing. And a lot of what's been issued and part of what we see some of the federal court decisions that have addressed these orders have come out, said there's a lot of vagueness in this. And that's potentially intentional in the sense of trying to just create an environment where not everybody's sure what's illegal DEI, what's legal DEI, or what can we still do. And we'll talk a little bit more about that. But yeah, what's driving this, and it was talked about during the campaign, is kind of a view that perhaps companies, the private sector, has moved too far in one direction to the exclusion of some other groups that you see the recent Supreme Court case from 2 terms ago with respect to college admissions, a number of folks that are in the administration now that previously were very actively involved in bringing private litigation in this space. It's clearly a high priority for this administration.
Can I just jump in briefly there? I think Ted makes a really great point that none of the orders that we're going to go over have changed the law. But what is really the wind at the administration's back here is the decisions related to affirmative action from the past year or so, where you have private litigants that are pushing against affirmative action, and you have the Supreme Court case that came out that provided additional guidance with surrounding affirmative action. A lot of that legal precedent hasn't necessarily been applied yet, or hasn't. But when you have a decision at the Supreme Court level, you still have a lot of nuances that have to work themselves out in the court system after that. And I think the administration's actions here are taking advantage of that in some respects. And it's sort of a tool that they have coming into this, because that is something that legally changed, but it was, well over a year ago.
Awesome.
Yeah, exactly right. So briefly, just on the executive order, the other few things that it does with respect to federal agencies, they're required to immediately stop any kind of DEI practices themselves as an employer. Then it requires federal contractors to certify under the False Claims Act, which Haley will talk about in a little bit, that they don't operate programs that promote unlawful DEI. Not just DEI in general, but illegal DEI. And then it discourages DEI in the private sector through some directed civil compliance investigations, among other things, asking each federal agency to identify up to 9 potential targets for civil enforcement action. The executive order has been subject to a number of legal challenges so far. 4 cases that have more directly challenged it. The current effect of it all is that although there have been some limitations imposed on the administration, the executive order mostly remains in effect pending the litigation. There's some exceptions. One of the cases prohibited the Department of Labor from requiring any of the certifications mandated under the executive order. Some of the other litigation has created what's known as a temporary restraining order or issued a preliminary injunction. Essentially, it means that it stopped the administration from doing certain things, though those orders generally only apply to the parties that have filed them. There's a case that was decided recently last month that only applied to a bunch of localities that filed a lawsuit against Department of Housing and Urban Development. But these cases continue to proceed through the courts, and the ultimate legality of the order will continue to be litigated. Next is Attorney General's memoranda. This was issued very shortly after she was sworn in. It builds on the executive order, the part of it that's directed towards the private sector. So it directs the Civil Rights Division within DOJ to investigate and to identify entities within the private sector, including in the educational field, that receive federal funds that have what it describes as illegal DEI programs, Again, builds on that directive to identify up to 9 potential civil investigations to bring. There's a deadline for that, for the division to make those recommendations. That is passed. The recommendations haven't themselves been made public, but we see, based on the next slide, that these continue to advance within the Department of Justice, this initiative. And that's the Civil Rights Fraud Initiative that got announced just about a little over 3 weeks ago. It sets up a new division within DOJ that's created to aggressively investigate and pursue any recipient of federal funds. That could be an award, a grantee, government contractor, perhaps somebody that receives aid, like through the COVID-19 relief programs, that receives federal funds and knowingly violates federal civil rights laws. Again, it's focused on violating the laws. There's been no changes to those laws. January 19th, January 21, no changes to the laws, but there's change in terms of what the administration views is an acceptable program, is not an acceptable program. And we'll talk a little bit about this, and Haley alluded to it. Also, just what the administration prioritizes for an investigation and the various collateral consequences that come along with that. Specifically calls out DEI programs that assign either benefits or burdens based on race, ethnicity, or national origin. And one of the other things that does fairly uniquely, and Haley will talk about what this means, but it strongly encourages the filing of False Claims Act cases by private parties. So the False Claims Act is not just something that the Department of Justice can bring a case based on, but at least as of now, there's some litigation about this. Any citizen that has unique information, non-public information, can bring a False Claims Act case against a company. I'll let Haley get into the details, but it's on behalf of the United States. And this gives an opportunity for financially motivated or politically motivated people or organizations to try to create some new law in this area as well.
And if you think about the universe of companies that have received a PPP loan, it's, I don't know what it is, probably 80+% of companies or something like that, like basically every organization. And I guess, Ted, if I'm not a lawyer, but basically what you're saying is, look, the laws haven't changed. However, the DOJ's focus and perhaps their interpretation of what does justice means has changed, and therefore they're going to start pursuing enforcement against companies that they deem to be, illegal. Whereas in the prior administration, which of course the DOJ is underneath the executive branch, prior administration didn't care about this stuff, and in fact probably was more in favor of what we historically think of as DEI. The Trump administration has said, hey, we're going to take these same exact body of laws and we're going to kind of interpret them a little bit differently. We're going to focus on them differently. And that's where companies have to be worried.
Yeah, I think that's a good way to encapsulate it. The law is what the law is. The courts will decide what the laws mean, but there's a great deal of leeway that a prosecutor, that the executive branch has in terms of what the priorities are and what position the United States government is going to take in bringing any cases. And just receiving a subpoena or a civil investigative demand is the term used under the False Claims Act, just getting negative publicity and then having to potentially litigate against the government carries a number of consequences that even if at the end of the day, a court decides this program doesn't violate federal civil rights laws, or this is okay, or the administration's view is not fully correct, partially correct, incorrect. There's a lot of steps along the way, there's risk along the way, and there's expense along the way.
100%.
I'll turn it over to Haley now to talk about the False Claims Act.
Thanks, Ted. So, to pick up where Ted left off, we're talking about risk along the way. And the False Claims Act is one of those risk factors that if you're someone who receives federal funds, and we'll go over exactly what that means, but if you're someone that receives federal funds, your risk of being tied up in a government investigation and having to defend your DE&I program or defend certain portions about your HR practices is heightened because you have some type of affiliation with the federal government. To Ted's earlier point, the administration can advance its goals and its priorities in a number of different ways. And while the courts will decide any type of investigation that the administration might want to institute at this point before the courts decide, or even as the court decisions are coming up, those investigations can apply pressure to institutions that change institution policies. So if you're paying attention to the news, you're seeing this all over the place. Targeted efforts against law firms, targeted efforts against universities. And they're all in different respects, and I don't mean to say that they're the same, but they are all applying pressure based upon those entities' affiliations with the government, whether or not they're government contractors or they're receiving money from the government. So this is an additional risk point for, it sounds like, just around half of our participants here who might be receiving some type of federal funds. And particularly under that first executive order that Ted discussed, you could be subject to a false claims investigation. So we're going to give you a quick overview of what that would mean so that when you're looking and talking about risk, you can kind of understand what a False Claims Act investigation might look like. So very briefly, what is the False Claims Act? It is a submission of a false claim, we'll talk about what that is, that you knew at the time you submitted it, or you should have known at the time you submitted it, was false. And there's a material statement within the false claim. A lot of people will think, well, that means maybe I'm submitting a false claim for money from the government, and I don't actually deserve that money. It's not quite that specific. When you submit a claim to the government for payment, perhaps you're a Medicaid contractor, you're a doctor providing services for Medicaid. That's probably the easiest example. And you tell the federal government, I did a procedure and that procedure cost me, I did the following procedure, but you didn't actually do the procedure. That is blatantly a false claim. You're claiming to the government that you're owed money, but you actually aren't. What we're talking here is something a little bit more nuanced. On a lot of government forms and a lot of government policies, when you submit a claim to the government, you're also acknowledging that you're complying with all government laws. And there might even be certification language within your policy, within your form, that says, I certify I applied with all relevant laws and regulations. Or something potentially even more specific, which is likely to be the case in the DE&I space, I certify that I do not have any unlawful DE&I programs. And by certifying that on a federal form, even if the claim that you're filing is completely unrelated to diversity, equity, and inclusion programs, you could be alleged to have been making a false claim because a part of the claim you're making to the government isn't true, or the government is going to allege that that part of the claim isn't true. So it's broader than just the claim itself, the request for money not being true. Go to the next slide.
It's kind of like the terms and conditions when you download like an app or something. It's like all that text you don't read. You're like, yeah, we're good. Because it doesn't relate to like the meat of the action, but this is what they're using as a mechanism.
Exactly. They're going to throw a bunch of things in there. And they historically have done that. There's often, there has been language in federal forms and federal claims for years that include different types of certifications. And in this instance, the federal government is going to start including a certification that you're not using unlawful DE&I programs. What exactly is a federal contract you have to be worried about here? If you're a federal contractor and you know you're a federal contractor, absolutely you're in this category of people that could be a target of a False Claims Act. But there are some broader components that you should be aware of. If you're receiving any type of government funds, you could be liable for a False Claims Act investigation. So a good example that Phil mentioned earlier were PPP loans. Now, you don't need to worry, it's not retroactive unless you're continuing to certify anything with respect to PPP now. But if there was in the future some government program that related to Small Business Act loans or certifications regarding Small Business Act benefits, that could be seen as a False Claims Act certification. So any type of government interaction or government funds is a potential risk point you should be aware of. There's some limits here. It's a 6-year statute of limitations from when you committed the certification. So you don't have to worry about this going on forever with respect to a single government contract you may have had. But particularly if you're continuing to contract now, you should be aware of it. Next slide. Now, Ted mentioned earlier a special part of the False Claims Act that makes this area particularly risky, and I think especially in this political environment. The False Claims Act allows a private party to file a claim against an institution that it thinks is violating the False Claims Act. So any private citizen can say, I don't think that I think that this entity has illegal D&I practices. They can file a claim, and the Department of Justice can look at that claim and decide if they want to intervene, whether or not they want to use the weight of the Department of Justice to investigate this claim. If the Department of Justice decides they want to proceed, that becomes a DOJ investigation, and all of the components of a DOJ investigation apply. Government's going to issue you a document request. You're going to have to deal with the government as the party who's pursuing the investigation. If the government declines to issue a request, the relator, this private plaintiff, they can keep going on with the investigation. They can file a civil claim in court, and the investigation can continue. So there's sort of two branches of recovery, and that's two branches. You're not going to end up defending the suit on both ends, both from the DOJ and from the relator. But it does mean that even if DOJ declines, the investigation could continue through this relator. There's a lot of financial incentives here. Relators can receive a range of 15 to 30% of any total proceeds that the claim might bring if the government pursues it. And I add that I think in this political environment, there's also some benefit for people who potentially have a position that they dislike DE&I programs. There's obviously a lot of people who are targeting DE&I programs, and I expect that we're going to see a lot of private litigation, False Claims Act litigation, just like that. That would be the subject of civil complaints. And finally, I sort of went over this already, that this is not, you're certifying that the payment itself is real or false. This is an express or implied certification that you'd be making. Those are the two issues that we're worried about under the False Claims Act. In terms of scope and risk here, these are the numbers from the past couple of years. And last year alone, there was over $2.9 billion worth of recovery for False Claims Act. A lot of that is driven by those private plaintiffs, those relators I was talking about, $2.4 billion last year. We expect this is going to increase for all the reasons I mentioned. The government has been saying that this is going to be a priority of theirs, and they're going to be using the False Claims Act to push these issues. Now, historically, the federal government has used False Claims Act to push a number of issues. But here in particular, I think we're going to see an increase, and we're already seeing an increase over the last couple of years, even under the Biden administration. So we'll see an increase, and I expect some of it will be focused on DE&I efforts.
Yeah, and just as context on some of these numbers, the biggest piece of the False Claims Act historically has been in the area of healthcare fraud. The federal government plays a big role there. There's so much federal money in Medicare, Medicaid. So that's one of the biggest pieces. The next biggest is usually in the defense contractor or general broader government contracting space. But then you see ebbs and flows depending on what's happening in the world. After the 2008-2009 financial crisis, big components of False Claims Act recoveries was in the financial services area. Banks and others that issued guaranteed loans, or issued federally guaranteed loans, rather. So these numbers are not DEI related numbers, but as Haley mentioned, each administration has its own priorities, and this is a tool that both the administration and private plaintiffs can utilize.
Yeah, I think that's a great point. And I think right now you might look at those turning points that Ted mentioned of like the financial crisis as making sense to be a huge generator of false claims. But hypothetically, you're starting to see DEI language in certifications. There's a 6-year statute of limitations. And the next administration may or may not try to enforce those claims. So you could end up seeing a lot of claims related to this and start seeing a peak from DE&I. I don't think we're going to see $2.9 billion from DE&I given the size of programs Ted just mentioned, but it could be something that comes out of this, especially if the next administration feels the same way.
Ted, do you mind allowing me to share my screen. And while you do that, I think what's really interesting about this is that it's not just, the perhaps slow-moving government that you have to look over your shoulder with. It's actually, individuals who are highly incentivized from a financial perspective to get these get these things going. And so we're going to be talking about a lot of like best practices here in the second part of this that I hope will help folks understand and decrease their legal liability, which I think is going to be extremely important. We're going to take a quick break right now. And I mentioned this giveaway that we have for anybody on the phone who is in an HR role, who's looking for a new HR system for your organization. We have a team of HR technology experts, most of which have an HR or recruiting background, who you can talk to, and you can talk to on a one-on-one basis to get advice on what HRIS, ATS, payroll, kind of you name it, learning management, performance management system that you want. And I'll put a link in the chat right now to book a call with one of these folks, but they're experts in their field. They'll understand your organization. They'll help you with vendor selection. They also have pricing data, etc. It's a totally free service that has a 4.9 star rating. And so if your organization is looking for a new HRIS or ATS or HCM or payroll or whatever it is, I highly recommend book a time with one of these folks. And as I mentioned, we have this special gift card offering where anybody by the end of the webinar that books a call will get a $50 gift card to kind of thank them for their time if they utilize this service. And so to give you a feel for some of the different use cases here, some of the organizations leveraging our advisor program, MIT, Indianapolis Colts, Chip City, which I wasn't familiar with, but I guess is a big cookie company. Frank and Eileen also wasn't familiar with, but apparently is a large women's fashion brand. Company last month looking for its first ATS, was searching for 4 or 5 months. I think it was 8 days after talking to an advisor here at SSR, they were able to find the right ATS for their organization. They just hadn't. These landscapes are so big, right? It's impossible to stay on top of them, and so leverage these advisors. Another team came in, sick of their existing system, all these legacy HRISs that probably are bolted onto your payroll. Team came in, got 3 great recommendations of modern systems with the employee engagement, the people analytics modules that they were looking for. And then, of course, you've got fractional folks coming in to help their clients as well, to just leverage these best practices. So again, if you're interested in booking a time with one of these advisors, you can scan this QR code. You can also use the link that I just put into the chat. And would love to help you out find the right HR tech, whether that's HRIS, HCM, EOR, even PEOs, LMS, performance management, etc. So just a quick break there. The other quick break that I wanted to do real quick is our networking minute. And I appreciate everybody who held off in the chat. I know you come on here and you want to network with other folks who are interested in DE&I. This is the time to put your LinkedIn URL in the chat. So if you're interested in networking with other folks who focus on DE&I, please put your URL in there. And that's basically an open invitation to say, hey, I'm dealing with these issues at my organization. Maybe I'm a fractional person, want to network with other people. And what I would recommend doing is just open up 2 or 3 or 4 of these profiles, connect with them. I left mine in there. Please feel free to connect with me. Set up a coffee chat or two. Find people who are in similar organizations. Maybe they're government contractors. Maybe they're in DEI specific roles and trying to figure this out. Share information, abundance mindset. Just please try to help everybody else in this community. And we'll also be sharing these URLs in a document so that you can kind of check them out afterwards. So with that, I'll hand things back to you, Ted, and we can get some more knowledge about how to decrease our risk and just kind of insulate ourselves from some of the liability that you guys have been talking about.
All right, great. Thanks, Phil. Let's connect the concepts. We'll talk about some of the enforcement implications of these DEI executive actions. We see in the chat so far a bunch of questions on what is illegal DEI. There actually has been some guidance issued on that. It's still a somewhat of an open question though, but we'll talk about it. As we mentioned, the executive order, if you're a government contractor, it requires you to make certain certifications. That you don't operate any program that promotes DEI, that violates any applicable federal anti-discrimination laws. So that's the key part right there. It's not just any DEI, it's DEI that violates the federal anti-discrimination laws, which remain the same. The next part that's new, compliance with applicable laws, is material to the government's payment decision. Haley talked about materiality as part of the False Claims Act statute. You can't just, anything that you don't comply with does not necessarily make a False Claims Act case. Has to be material to the government's payment decision. Here, the contractor is agreeing in advance that it is material. That's not dispositive under the False Claims Act law, but it is persuasive. So it's something that a court would consider by the government making this explicit statement and the contractor agreeing to it in the front. But in this essence, what this does, it creates that express certification environment. Haley talked about the different types of False Claims Act cases. And by agreeing it's material, it means that the government or these private relators will assert, or we'd expect them to assert, that every claim for a payment that violates, will violate the FCA if the contractor has a program that arguably constitutes illegal DEI. So what does that mean? What is illegal DEI? The administration has come out with some guidance. So back in March, there was a joint guidance from the EEOC and DOJ on what is illegal DEI. And in essence, it's taking an employment action. We'll talk about what that might mean. That's motivated in whole or in part by race, sex, or another protected characteristic. And there are a few things that are specifically identified in this guidance document. Some you'd expect: quotas, explicitly trying to balance a workforce, disparate treatment. And there are certain ways, we talk about what's an employment action. There are a few things specifically called out. So hiring, firing, promotion, typical, fringe benefits, trainings, specific mentorship or sponsorships, fellowships, selections for interviews. Also limiting or segregating or classifying employees, and specifically called out membership in affinity groups. Now, it's not saying affinity groups in and of themselves is illegal DEI, but limiting membership in them. And it also specifically says that applies to employer-sponsored activities. So making available your company's break room, resources, time. Recognizing certain time spent on activities that might not be an official organization, but allowing that to, or recognizing that under your company's policies. Harassment, and again, specifically calls out that DEI training could give rise to a colorable hostile work environment claim. It's not saying everything, but it's putting the flag out there. And then retaliation, including retaliation for those who raise complaints about potentially illegal DEI programs that a particular employee thinks would fall within these categories.
Can you go back when some of these have been the law for a while. Retaliation has been the law, that you can't retaliate in someone for their race, sex, or other protected characteristics. Same with quotas. There's other things in here that are within the guidance that may or may not end up being something a court agrees on is illegal DE&I. But what the administration is saying is that they may view this in their investigations as illegal DE&I. So take the example of limited membership in workplace affinity groups. You have a workplace affinity group. If you're excluding anyone who's not that affinity from being a member, the administration may see that as illegal DE&I. But having the affinity group that has full membership opportunities are open to everyone at the company, regardless of their professed affinity, that is more likely not to be seen as illegal DE&I. So again, it's not that the law has changed. Many of these things on this list have always been uh, against the law, but the way they're interpreting is sort of cutting it a lot closer than perhaps it has been cut in the past. Would you agree with that, Ted, or do you have?
Yeah, no, absolutely. This is a showcasing of the priorities changing. This is not a memorandum that would have been issued by the previous administration because as Haley said, it's not like it's reinventing the law or anything like that or creating a new law, but it's what's the priority and what does the administration at least think is illegal DEI. We have to caveat that this is guidance from the EEOC and DOJ, and guidance by a federal agency is not necessarily law. It is very indicative of what the administration is going to spend resources on in terms of its enforcement priorities. But a court's going to decide ultimately, or would decide ultimately, what falls within illegal or legal within the federal civil rights laws.
And to your point, Ted, even if you're the court sides with you, it could still make your life not very fun for a while.
Exactly.
By the way, we lost the slides, just as a heads up. I think you might have
Oh.
paused the screen share. There we go.
Oh, okay. Okay. Hopefully.
And I know there's a lot of questions in the chat, and a lot of things are hard. This is what the administration has said, and as far as what does it mean? Can we no longer have DE&I training? Those are things that the courts will have to sort out. That's the administration's current view. That could be a risk point that it draws the administration's attention. It doesn't mean that it is or is not illegal. And I do hate to be the lawyer on the call that says it depends, but that is sort of the nuance of where we are. It's unclear at this point.
Yeah, no, exactly. A lot of this is going to depend on the circumstances, the nuances of a program, and the risk tolerance and the risk and the ways in which risk can develop. And we'll talk a little bit about that in a few slides, how you might receive inquiries from the government. You also just might get a hotline request from an employee and the sensitivities that are involved there. So yeah, Haley's exactly right. We don't like to be the lawyers that say it depends, but in this area, especially since it's relatively all new policy pronouncements, not a lot of detail coming out of the administration. They put out some of these memos. They're relatively short, provide some guidance, but this is going to get sorted out over time, and it's going to be very fact specific. So one of our big takeaways here is going to be you should consult with your in-house legal department, consult with outside counsel about your specific practices, and we'll talk a little bit about those best practices in a bit. So a few other areas of guidance that have come out over the last several months, one from the federal government, one from a collection of state attorneys general. The US OPM came out with a memo. This is directed towards federal agencies, but gives some insight into what the administration views as acceptable and unacceptable practices. Directs agencies that they can't use diverse slate hiring, that has to eliminate special emphasis programs that promote DEI based on protected characteristics, and again, to disband ERGs that advance opportunities based on protected characteristics or that restrict membership. So kind of in line with the prior slide with respect to, and I see some comments in the chat about ERGs being open to everybody, open to allies, as opposed to the restricted membership that's talked about here. Conversely, a number of states organized by Massachusetts and Illinois have come out with a guidance document that recommends various practices that, in these state AGs' views, continue to be legal and that employers should continue to practice. So wide-scale recruitment efforts, setting standards that try to reduce the impact of biases, ensuring equal access, and then putting out trainings on unconscious bias, inclusive leadership, disability awareness, among other topics. In some ways, these are conflicting. These are two different voices speaking here, but it's kind of a pushback on some of the new administration's views on things here. So some of the open questions. Still, what is illegal DEI? That's still an open question. We have a few slides on it, a number of administration statements about it, but there's still a lot of uncertainty. The administration's views will dictate what's an enforcement priority, where it's going to spend resources, where companies may be facing risk from receiving government subpoenas or private parties bringing a False Claims Act action. But ultimately, courts are going to decide what is illegal DEI, absent an act of Congress or something new coming out that actually carries the force of law. Also, open question, will courts find that these certifications that are being required are material to every contractor grant, to some contracts and grants? Like I said before, the fact that the contractor is going to be required to certify this is material, compliance with federal civil rights laws is material to the government's payment decision. That's not, although that could carry a lot of weight, it's not dispositive. It's not going to carry the day necessarily. And then what activity is going to be sufficient to establish what's called scienter? Haley talked about this. There's different ways. The False Claims Act requires a knowing intent that could be established through either you actually knew you were defrauding the government, you acted with reckless disregard, or you had deliberate ignorance. Some recent Supreme Court case addressed some of this and said that deliberate ignorance can include if you're aware of a substantial risk that a statement you're making is false, while you intentionally avoid confirming it. But so here you have a situation where there is some uncertainty. But the court also said if there's a good faith interpretation that you might have that a requirement about an ambiguous requirement is a defense, even if it's ultimately mistaken. So if you believe that your program complies with federal civil rights laws and later some court decides that's not the case, the scienter element requires that you didn't have a good faith interpretation at the time that you made your various certifications. And we'll talk about in a few minutes some of the best practices that incorporate that type of a defense. And with that, I'll turn it over to Haley.
So we want to emphasize a couple issues that might put you on the front lines of responding to some either government interaction or relator interaction or even employees that could turn into an investigation. So the issues that we've been talking about that can give rise to investigations can come up in a number of different areas. Looking at the poll results, it seems like a lot of you are involved in the personnel side. I'm sure you all handle employee hotline calls, employee complaints. These issues are likely to come up there. I think that's probably the area you will see them the most. Beyond that, you could be subject to one of these qui tam lawsuits, which is that private plaintiff who files an FCA case. You could get an investigative demand from the federal government. You could get a letter from the EEOC. You could receive an unannounced visit from the government. That's less likely in this type of scenario. Or there could be some type of government audit that you're subject to if you're a federal contractor. So these are all ways that these issues might arise, and you should be aware of all of those different avenues when you're thinking about and responding to those types of complaints, particularly at the hotline calls. Some best practices on the next slide that you should be thinking about now. Number one, you're probably already doing this. Review your DE&I practices. Are there certain things that you maybe should be expanding? Maybe you need to expand your affinity groups to be open to all. Maybe there's some language nuances you want to adjust to make it very clear that you're not doing anything that could potentially be considered illegal. Important here is to document your conclusions with respect to the legality of your DE&I programs. As Ted mentioned, we have this good faith requirement, or the scienter requirement in proving a False Claims Act. If you made a good faith determination that your DE&I program was appropriate, it's going to be harder for the government to establish that you knowingly submitted a false claim or you knowingly had an illegal DE&I program. So make sure you document those types of determinations. If you aren't sure, if there's certain things you're doing that I really think that there's some specifics here that potentially could be on the line, it's good to consult legal counsel, both to get that determination from legal counsel and maybe change your programs if you need to, but also there's always a possibility you could say, I was advised appropriately, I consulted legal counsel, I did my due diligence, and it's going to be harder to establish that you intentionally try to defraud the government. Having a policy on how to handle these issues when they come up, particularly if you are a government contractor, you should have some type of policy that establishes who's going to be handling this when we have to certify, who's going to be handling this if we get a government inquiry, so that there's one point person in your institution that's handling that. If you have a compliance program, it's probably going to be them, or a compliance office. If you do it already, have an employee hotline and make sure that employee hotline is well staffed, and that employee hotline, you're following up on things that you receive. A couple of different reasons. Number one, like most importantly, if you have an employee that's dissatisfied or they're making claims that relate to DE&I, you want to make sure that those are addressed, both so that you can show the government that you addressed them, they somehow come up from a government inquiry, and so that employee isn't incentivized to go out and report what they're upset about. So addressing and responding to those types of complaints immediately, whether or not you take the side of the aggravated employee or not, is really important to respond to those. And then, as always, be mindful of potentially retaliatory conduct, or if an employee could think that you're being retaliatory. Government whistleblower programs are only expanding. We won't get into it. That's an entire different presentation, but it's important to ensure that you're not retaliating against anyone who might be a government whistleblower, or that you aren't being perceived as being retaliatory. The next slide, please. I mentioned making sure that you respond to complaints effectively. Just things to keep in mind as you're receiving those type of complaints. For the sake of time, we're just going to keep going. Always important when you are handling these types of issues, particularly if you are involving legal counsel, is to protect the attorney-client privilege. So if you have legal counsel in your company, or you're consulting outside counsel, and you're relying on what they have been telling you, and you're going to communicate what they've been telling you, make sure you're protecting that privilege, particularly if you're going to be reframing or discussing what legal counsel has told you. What you don't want to have happen is a government investigation comes to your company, and while you went out and talked to legal counsel, you went back and talked to everyone else at your company about what legal counsel said, but you didn't include a lawyer on those communications. And therefore, everything that you said is now no longer protected by the attorney-client privilege. So keep that in mind if you are under investigation, or even if you're trying to receive some advice from counsel to protect that privilege. Don't talk casually about complaints. If you received a hotline complaint, particularly if legal is involved, you want to minimize the distribution of how you're responding to that. All of these things that you might be doing to respond to hotline complaints could create records that would be discoverable by the federal government or by a relator. So you want to keep the number of people who know about complaints fairly small. If you're investigating them, keep that number small. If counsel's involved, keep counsel involved and copied on all your communication, so all of that ends up being protected if you end up getting a government inquiry. Lots of other pointers on there we won't get into. We want to get to the conclusion to make sure we go over these important things. Moving forward, these are the things we think that you should keep in mind and really focus on. Well, we can't give you a crystal clear definition of what illegal DE&I is. As time goes on, there's going to be more indicators that can support what is and is not illegal DE&I. We're going to have court cases. We're going to see settlements. Those will all help point towards what illegal DE&I is going to be under this administration. You're going to start seeing more and more of those markers as time goes on. DOJ has created a task force that is going to be focusing on these False Claims Act matters. And as Ted mentioned, there's going to be investigations into these target companies that agencies are coming up with. So you'll start to see that in the news. It doesn't mean that anything is changing with respect to the legality of certain DE&I practices. It just means, as we've been focusing on this entire time, the administration is focused on those issues. So until you see a court case, nothing has really changed with respect to what illegal DE&I is. For now, document the conclusions about your DE&I program. If any of these factors apply, you're a government contractor, meaning that you are higher risk and you have DE&I programs, that might be something you want to make sure that your legal counsel has reviewed, either your in-house or external counsel. If you have programs that you think might have appeared on that illegal DE&I slide, maybe you have something you think might be a quota, you have some other issues that you think fall under that, something you might want to consult counsel with. If you have high-risk phone calls where employees are complaining about affiliation programs that they aren't members of, or they have other complaints that relate to DE&I, fully investigate those. If there's particularly high risk that you think that there's some validity to their complaints, or you think this program should be structured differently, those are things you should be investigating. And of course, you get any type of government inquiry that should be forwarded to your legal counsel as soon as you receive it, because that's something you want to address at the earliest possible opportunity before creating any additional record related to the matter. I believe that is the end of our presentation here. Our contact information is on the slide. Ted and I will put our LinkedIn's in the chat, so you can always find us there. We really appreciate the time. And Phil, I don't know if we have time for questions.
It's a little tight, and I know people have to get back to whatever they need to do. We did have a number of questions in the chat as well as RSVPs that I think like probably the answer to every one of them is it depends, and you should consult counsel. And I think, thanks to Ted and Haley for making themselves available, and I definitely recommend to ping them if your organization is facing one of the situations that Haley outlined in the previous slide. I wanted to thank everybody for joining today's session. Of course, thanks to Haley and Ted for the amazing insights here in the ever-evolving landscape around DE&I and enforcement, how these rules are being interpreted, case law, what we can do to decrease our liabilities while still maintaining our employer brands and our ERGs and everything else. We're going to send a number of takeaways. We're going to send the takeaways doc with a lot of the resourcing here. We're going to send the slides. There's a job board I just put in the chat that we run as well, that a lot of folks I know on these calls you're out there networking because maybe you're thinking about what's next in your career. So please take advantage of that. Take advantage of our advisor program. If you're buying HR technology, you or your organization or somebody in your network. And please, stay on the pulse of this, because this is a very evolving landscape. We're going to have a continued sessions about DE&I from a legal perspective, from a tactics, strategy, practitioners. We're just going to continue to educate our community about this topic, because you've got the False Claims Act, super scary, the DOJ, the individuals. There's multiple vectors here that increase your liability. It's an evolving landscape, but these are important programs. And I know that the folks on the call are very passionate about continuing their work while still not putting yourselves in the crosshairs, which is also extremely important, because even if you win in court, to Haley and Ted's point earlier, it can still be a pretty painful process that drains a lot of resources, time, headspace, etc. So again, thank you to everybody on the call who joined, share your insights, your questions, networked. Thanks to Haley and Ted, and I hope that everybody has a phenomenal rest of your day.
Thanks, Phil.
Thanks.